Swayam Prabha. Digital India. Educated India.
Welcome to lecture number 14 of the subject Business Law, and topic of discussion is the Limited Liability Partnership Act 2008 Part 1. I am Dr. Rama Bansal, working as Assistant Professor at Arya College, Ludhiana, and this is a DTH Swayam Prabha MHRD New Delhi sponsored project. Today we are going to discuss about the introduction part of limited liability partnership, salient features of the act, nature and scope of Limited Liability Partnership Act 2008, the different chapters starting from chapter number 1 preliminary, chapter number 2 nature of limited liability partnership, chapter number 3 incorporation of limited liability partnership and matters incidental thereto, chapter number 4 partners and their relations, chapter number 5 extent and limitation of liability of limited liability partnership and partners, and chapter number 6 that is about the contributions. So we are going to read first 6 chapter in this part and rest of the chapter in the part number 2. So let's start with the meaning, the introduction of the limited liability partnership. So the Lok Sabha passed this Limited Liability Partnership Act on 13th of September 2008, but it received the assent of the President on 7th January 2009, and hence it was given the status of Limited Liability Partnership Act 2008. So this act, Limited Liability Partnership, is applicable to whole of India, including the state of Jammu and Kashmir. This was a very new form of partnership in India, but already in other countries of the world it was prevalent, and among that United States and United Kingdom were the first amongst all to introduce the concept of LLP, that is Limited Liability Partnership. They were the first countries to start this, wherever India has picked it up in 2008. So the introduction of LLP was a good step for the small and medium type enterprises and professional firms of the company secretaries, chartered accountants and the advocates. Means there was a partnership act which was into the prevalence, but in addition to that, for the smaller and the medium enterprises and the persons, the professionals, including chartered accountants, company secretaries, etc., the new act, that was a Limited Liability Partnership Act 2008, was introduced. So now what is this act? This is a formal partnership between at least two business partners. The maximum number of partners is not limited, but the minimum number of partners, as in case of the other partnership act, it is at least two members, two business partners. So each partner in this LLP is provided with the limited liability, as its name indicates, limited liability partnership. Every partner would be provided with a limited liability. They are not responsible for the business debt or the liabilities. They are not responsible for the firm's debts and liabilities. So this is the distinguishing feature which distinguish it from the Partnership Act. So in this, every partner has a limited liability. So in this case, in LLP, partners are not responsible for the negligent or wrongful or malpractices acts of a single partner. Every partner is responsible for his own negligence. Means if one partner is doing something wrong or doing something which is counted under the malpractice, so only that partner would be responsible for that. The other partners would have the limited liability. Other partners would not be held liable for the negligence or the wrong act of the other partners. So LLP means a body corporate and it has a legal entity which is separated from its partners. So, as we know, LLP is a separate legal entity, but it is liable to the full extent of its assets. It's separate from its partner, but it is liable to the full extent of its assets in case of dissolution. The liability of partners would be limited to their agreed contribution. When the LLP is formed, there is a proper process for that. We will read in the further slides. So the partners agreed in between themselves. There is a mutual consent between the partners that in case of any kind of liability, so every partner would be liable for a agreed contribution which was decided at the time of entrance into the partnership. So this type LLP is a business format and which is the combination of the partnership firm and also has the advantage of the private limited company, because as in the case of private limited company every partner has a limited liability, so this advantage is there and it has a flexibility of the partnership firms, means it is a combination of both these type of companies or the firms. The limitations of the partnership act, that partnership firms and the rigidity of the companies has led to the birth of the LLPs, because there in case of companies there is a lot of rigidity involved, so certain restrictions are there and the partnership firms are also facing the limitations like unlimited liability of the partners. So the limitations of partnership firms as well as the rigidity of the Companies Act has led to the birth of limited liability partnership. It is a combination of both these. It is a in between way where the partners in this type of company, in this type of partnership can have advantages of the partnership firm as well as the benefits of the companies. So it is a hybrid between a company and in the partnership. It is not the same as limited liability company. It is different from limited liability company, but this is a hybrid form of the firm which has the benefits of partnership as well as of the company. So this was the introduction to LLP. It has certain features of Limited Liability Partnership Act 2008. Let's read them. The first feature is it is a hybrid form of organization. Hybrid means a combination. It has the features of partnership under the Partnership Act 1932 and also having the features of the Companies Act 1956 at present, the Companies Act 2013. It has features of both these acts. It's a hybrid form of organization. And the act which was Indian Partnership Act 1932, it is not applicable to LLPs. Means there is a separate act, Limited Liability Partnership Act 2008, to be implemented on LLPs, and the Indian Partnership Act 1932 is not applicable on these type of organizations. And these LLPs are administered by the Registrar of Companies. In the further slides, we will read the process how these are being administered. So this is the first, that is the first feature of the LLP 2008, and that is the hybrid form of organization. Second feature is the perpetual succession. So what do we mean by the perpetual succession? LLP is a body corporate and legal entity separate from its partner. So as the case of company, as the company is separate from its members, similarly LLP is separate from its partners. It is counted as capable to enter into a contract at its own name of acquiring, owning, holding, disposing of property. The property may be movable, immovable, tangible or intangible. The LLP is capable of doing all these things at its own name because it has the separate legal entity apart from its members. And Being the partnership firm, it can be sued at its name, or it can sue to the third parties in case of default. And it is capable of doing and suffering other acts as a body corporate may do or suffer. Body corporate means companies, as the companies have the rights to sue or to do anything or to suffer losses. All these things are applicable to the limited liability partnership. So this means it has the perpetual succession. Next feature of this act is that number of partners. So in every LLP, limited liability partnership, there should be at least two individuals as the designated partners, and out of these two designated partners, one designated partner must be resident in India. Let's suppose there are two partners in the LLP. So out of those two, one must be in India, one must be resident of India. And as I already said, there is no limit on the maximum number of partners, but at least two partners must be there in LLP. Next feature is separate legal entity. So LLP is a body corporate and it has a legal entity, separate entity from its partners. So it would be liable to the full extent of its assets, with the liabilities of the partners being limited to their agreed contribution in the LLP. Means partner would be responsible only for an agreed contribution in the LLP. Rest of the responsibility is should be of the LLP, but the partners would be responsible only for a limited contribution that was already agreed at the time of entering into the partnership. So no partner would be liable on account of independent or unauthorized actions of the other partners. All the partners are responsible only for their misconduct, only for their negligence, or only for any act of malpractice of their own, but they are not responsible for the acts of the others. The liability of LLP and its partners who are found to have acted with an intent to defraud creditors for or for any fraudulent purpose shall be unlimited for the all. That means LLP would be responsible for all, but the partners would be responsible only up to an agreed contribution. Next point is rights and duties of the partners. The rights and duties of this limited liability partnership would be governed by the agreement between the partners when they have entered into it. So when the limited liability partnership was formed, the partners have entered into LLP agreement. So whatever the rights and duties are being defined in that agreement, so the partners are to abide by it. Next is conversion into the LLP. So suppose there was a partnership firm which was governed by the Partnership Act 1932. Now they want to convert themselves into limited liability partnership. So there is a provision, means any firm, any partnership firm formed under Partnership Act 1932 may be converted into a limited liability partnership under LLP Act 2008. A private company or an unlisted public company may also be converted into the LLP provided there is no security interest subsisting on the date of application for the conversion. That means the other forms of organization can also be converted into the limited liability partnership subject to a few conditions. Books of accounts of an LLP. Like other undertakings, like other form of organizations, LLP would also be in requirement to maintain the annual accounts, and those annual accounts should represent a true and fair view of their state of affairs. And every LLP has to prepare a statement of accounts and solvency every year, and that statement is to be submitted with the registrar of this LLP every year. That means every year the LLP has to prepare to maintain the annual accounts with the true and fair view, and this statement is to be deposited, is to be submitted with the registrar of the companies. And the like the other undertakings, the accounts of LLP will be audited every year, and all filings under the LLP Act to be done electronically. Similarly, the registrar may furnish information or provide copies and extract certifying the same by affixing the digital signature. That means where the LLPs are required to file the records of the company electronically. Similarly, the registrar may sign it digitally. So in short, the every LLP has to maintain the account and to submit to the registrar, and it is to be done on the annual basis. Accounts are to be audited and to be submitted in the electronic form. Winding up of LLP. So winding up of LLP may be either voluntarily, means when the partners wish to do that, or by the tribunal to be established under the Companies Act 1956 or at present Companies Act 2013. Changes in LLP. Once the agreement is being done, later on the required changes can be done. Required the compromise, the or arrangement, including the company wants to merge with someone, they want to have amalgamation. So all can be possible, all is possible, but within the accordance of the provisions of the Act. And in case of the companies are defaulting, they are not following the provisions of the Act, they have to be fined with the heavy penalties or with some kind of imprisonments if are mentioned in the accounts, in the acts. So by now we have learned about the basic features of LLP. Now we will discuss about the nature and scope of the activities of LLP Act 2008. The first thing is the limited liability partnership is a partnership formed and registered under Limited Liability Partnership Act 2008. It is a body form of corporate and it can be incorporated under the Act, that is Limited Liability Partnership Act 2008. And any change in the partners of LLP shall not affect its existence, like in case of the partnership. So it would not affect the rights and liability of the LLPs. There should be a written agreement between the partners or between the LLP and partners, which will determine that what is the duty and liability of the different partners of LLP. So now there are a few definitions, the terms which we will be using throughout the topic. So it's very important to know these terms. The first term is foreign limited liability partnership. A LLP formed, incorporated or registered outside India which establishes a place of business within India is known as the foreign limited liability partnership. Next, the term is the partner. Any person who becomes a partner in a LLP according to LLP agreement, means any person who enters into a limited liability partnership according to the agreement, that would be counted as a partner. Now we come to the financial year. This is a very common term. So the financial year means it is starting from the first day of April to the 31st day of the March of the following year. Sometimes LLP also prepare their accounts biannually, but the financial year would be from 1st April to 31st March. So LLP, if incorporated after the 30th day of September, the financial year may end on 31st day of the March of the next following year. Means the financial year would be from 1st April to 31st March. Now this was the introduction of LLP. We have known about various things, but now we are going to study the most important part or regarding the LLP, that is the provisions of Limited Liability Partnership Act 2008. There is an act. It includes the various provisions. So we need to read all the provisions chapter wise. So the chapter number 1 is regarding the preliminary concepts. what we have read till now in this topic, in this lecture, this all is included in the preliminary chapter of Limited Liability Partnership Act 2008. So it defines the scope, the definition, etc. So we have read about it. The next chapter, chapter number 2, is nature of limited liability partnership. So more or less we have also studied about it, but we will give a quick view to it. The chapter 2 is about the nature of limited liability partnership. Under this, the first one is limited liability partnership to be the body corporate. So as we have already read, the limited liability partnership is a body corporate and incorporated under the act. It has the legal entity separate from its partner. Second is non-applicability of Indian Partnership Act 1932. The provisions of Partnership Act 1932 will not apply to a limited liability partnership. It has the different act, and the firms formed under the Act of Limited Liability Partnership 2008 would be governed by only this act, and the provisions of Partnership Act 1932 would not be applicable. Next is about the partners. Any individual or body corporate may be the partner in the limited liability partnership. But the only condition is that any individual or the body corporate who is going to enter into the partnership should be capable of becoming a partner. Means that it should, if it is an individual, then it should not be a minor, it should not be of unsound mind, and in both other cases it should not be disqualified by the law. Means any person who has the capacity to become a partner can be a partner in LLP. Next is minimum number of partners. Limited liability partnership should have at least 2 partners. And at the time, if the number of partners in any time, if the number of partners is reduced below 2, and the business goes for next 6 months, and the person who is alone working as a partner has the knowledge of the fact that he is carrying the business alone, shall be responsible alone for the obligations of LLP. That means if the number of partners at any time is less than 2, then in that case the partner who is running the business should be sole responsible for whole the responsibilities of LLP. Next is designated partners. So there must be at least 2 designated partners who are the individuals, and at least one of them should be a resident of India. And in case all the partners are the body corporates, so then at least 2 individuals who are partners of such LLP or nominees should act as designated partners. That means either there should be 2 designated partners who should be individual, or if all the partners are body corporate, then the 2 partners should be designated as the designated partners. And who can be a designated partner? If the incorporation documents specify that these are the designated partners, only those persons would be designated as designated partners. Or states that each of the partner from time to time of LLP is to be designated partner, so every such partner would be a designated partner. And according to agreement, if a partner may cease to designated partner, but the only condition is it should be according to LLP agreement. And last in this is, an individual shall not become a designated partner unless he has given his prior consent according to the act. That means if any person is being designated as the partner in LLP, but in actual his consent is not taken, it would not be designated partner. And every LLP shall file with the registrar the particulars of all the designated partners within the 30 days of their appointment. So that means, in short, there must be 2 designated partners, they should be individual, and this must be conveyed to the registrar of the particulars within the 30 days of their appointment. An individual eligible to be a designated partner shall satisfy such conditions which are mentioned in the Act. And every designated partner would be issued a identification number which is known as DPIN, and this number is to be issued from the central government. And liabilities of the designated partner would be as the responsibilities of the other partners are, or as defined in the Act. Then the liabilities of the designated under the liabilities of the designated partner, a designated partner shall be responsible for doing all the acts matter things as required to be done by the LLP. That means the important task on the of the LLP are to be done by the designated members of LLP, and they are liable to penalties imposed on LLP for any contravention of the provisions of the Act. Changes in the designated partners. If LLP wants to change the designated partners, so it is required for LLP to do this change or to fill the vacancy only within 30 days of the arising of such vacancy due to any reason. That means when vacancy is arise, any designated partner wants to change or company wants to change him, so as soon as the vacancy arises, it must be filled within 30 days of that vacancy. And if no designated partner is appointed within the stipulated time, so each partner shall be deemed to be a designated partner in that case. Next is punishment for contravention of section 7, 8 and 9. So, if there is any contravention regarding the designated partners which we have discussed earlier, so every partner shall be punishable with fine, which shall not be less than 10,000 rupees, but which can be extended to 5 lakh rupees. Means it would depend upon the court the amount of the fine, but the minimum fine is 10,000 and the maximum can be the rupees 5 lakh in this case. So the designated partners in place, their role is very important in LLP. So there are different provisions mentioned in the Act, and in case of default there is a penalty with fine. So this was about chapter 2 of the Act. Now we come to the chapter 3 of the Act. The name of the chapter is Incorporation of Limited Liability Partnership and Matters Incidental thereto. So the chapter 3 includes 1. The incorporation document. For a limited liability partnership to be incorporated, so this includes the process of incorporation. So for their incorporation, first thing is 2 or more person who are associated for carrying on a lawful business. Lawful business means which is acceptable by law, and their objective to do this business is to earn profit, shall subscribe their name to an incorporation document. That means the first thing for the incorporation which is required, that means the names of the 2 or more persons, what would be the business, and the motive is to earn the profit, must be submitted in the incorporation document. And this document is to be filed with the prescribed fees. The fee will change from time to time. What is the prescribed fees that must be submitted with this incorporation document in the office of the registrar? And the office of registrar would be that office, the state in which the registered office of LLP is situated. So, next, a statement in the prescribed form made by either advocate, company secretary, chartered accountant or cost accountant, the person who is involved into the process of the formation of LLP, and by anyone who subscribed his name to the incorporation document, has to submit this document in the prescribed form. And the incorporation document shall be in the form as it is prescribed in the Act. The state and the name of the limited liability firm would be there. The state, the proposed business of the limited liability partnership. That means when an incorporation document is being submitted, so it should be according to the law, according to the act, and then what would be the name of the LLP, what would be the business of the LLP, what would be the address of the registered office of the LLP, and it would also include the name and address of each of the persons who are the partners of the LLP on its incorporation. So in the names of the name and addresses of the persons, that is the designated partners would also be mentioned. So as we have already read, the one of the designated partners should be the resident of resident of India, and the person should be an individual person, and it should contain all other information which is to be mentioned according to Limited Liability Partnership Act 2008. Next is, if a person makes a statement under clause 6 of subsection 1 which he knows to be false, means if any information knowingly is put into the incorporation document which everybody knows that it is a wrong information or does not believe to be true, so every such person would be punishable with imprisonment which may extend to 2 years, and with this imprisonment there would be a fine in rupees which would vary from rupees 10,000 to rupees 5 lakh. That means no false information should be submitted into the incorporation document. Next is incorporation by registration. So if it is the process, then the registrar shall register the incorporation document as the document is being submitted with the prescribed fees and all other formalities. Now the registrar shall register that incorporation document, and while registering the incorporation document, he would issue a certificate by the name specified therein in the incorporation document. The certificate issued under clause B, which we have just read, shall be signed by the registrar and authenticated by his official seal. It would be a proof that incorporation document is being registered with the registrar. And this certificate shall be the conclusive evidence that LLP is incorporated by a particular name specified therein in the incorporation document. Next is registered office of LLP and change therein. Every LLP when goes for the incorporation process mentions a name of the registered office, means where it would work. So it is there in the incorporation document if there is any change. So before that, let's read if any kind of information is there from the registered office side. So all the communications and notices and the information would be registered, would be addressed only at that registered office which is being mentioned in the incorporation document. And if a document may be served on a LLP or a partner or designated partner by sending it by post, that means the registered post is the sufficient way to send the documents at a registered place of LLP. And if LLP wants to change the place of its registered office, then they can file this again with the registrar with the notice of such change. And if the LLP contravenes any provisions of the section, then LLP and every partner would be liable of a fine which would be at least rupees 2,000, but which may be extended to 25,000 rupees. That means if any kind of change is being made in the registered office without informing to the registrar, then LLP and every partner can be charged with a fine that is ranging from rupees 2,000 to 25,000. Next is effect of registration. On registration, a LLP shall by its name be capable of, once it's registered, so it would be capable of suing and being sued by the third parties, acquiring, owning, holding, developing, or disposing of the properties, having a common seal if it decides to have one. That means the LLP can work, can operate at its own name. So it can buy the property, it can own the property, it can sue the third parties, or third parties would also be able to sue the registered firm. Next clause is of name. So every limited liability partnership shall have names, that is limited liability partnership or LLP, as the last words of its name. It's the mandatory one that every LLP has to use the word limited liability partnership or LLP at the last of its registered name. And no limited liability partnership shall be registered by a name which in the opinion of the central government is undesirable. That means no LLP can choose that name which is undesirable by the central government. So it should also not be identical or should not resemble too near to other names of the other LLPs. Means they should have the different name which is already not registered, and it should not be the name which is undesirable by the central government. For this, the LLPs can reserve a name with the registrar. So now let's talk about the reservation of the name. So a person may apply in such form or manner prescribed by the fee as may be prescribed to the registrar for the reservation of a name. So for reservation of a name, there would be an application in which there would be a proposed limited liability partnership firm's name. And if the LLP wants to propose any change, so that means application can be filed with a prescribed fee to the registrar in which there would be a prescribed name for LLP. On receiving of that application and on receiving of that prescribed fee, and if the registrar feels so that the name can be reserved, this name is desirable, this name can be had, and this is not a common similar name which is already in the existence, so the registrar may allow for reserving the name, but there is a limitation of the period of 3 months from the date of intimation by the registrar. That means that particular name would be reserved for 3 months from the date of intimation. If LLP wants to change the name of LLP, so in that case also an application would be filed with the registrar in that what name they want to have. Again, this name should not be identical, it should not be it should not resemble too near to any other LLP's name, or that name, if other name as to be likely to be mistaken for it. So the purpose is that the name should be unique, the name should be distinct from the other names, and it should be desirable whether they want to have the name, whether LLP wants to change the name. The process would remain same. They can reserve a name with the registrar with an application or with the requisite fee, and on receiving the application and fee, the central government may direct such LLP to change the name or to have the name. If it is a case of change the name, the central government may direct to change the name within the 3 months after the date of that issued direction. And any LLP, if fails to comply with the direction, then in that case that LLP shall be chargeable, punishable with the fine, and that fine would vary from rupees 10,000 to rupees 5 lakh. And every designated partner of LLP shall also be punishable with the fine, which will also range from rupees 10,000, but it would be maximum rupees 1 lakh. So every LLP has to comply with the directions of the Act. Next is application for direction to change name in certain circumstances. So certain circumstances means the special circumstances, like if any entity found that which already has a name similar to the name of LLP, they think that it is a very resembling name and it is creating a problem for them to operate into a business. So in that case, registrar can give a direction to change the name of LLP immediately. So means if a registrar thinks that the any LLP has the similar, identical or too close name of any which is very close to the name of the other LLP, the registrar may issue a direction to change the name immediately. The registrar shall not consider any application unless the registrar received the application within 24 months from the date of registration. Once the period of 2 years have gone after that registration of the name, then such change is not possible. If any application is being filed within the 24 months of the date of registration, only the registrar may allow for change of name. And change of registered name provisions would include any limited liability partnership may change its name register with the registrar by filing with him a notice of such change in the manner prescribed or on payment of such a fees which is prescribed by the registrar. Next is penalty for improper use of words LLP or limited liability partnership. As we have read, every partnership firm, every limited liability partnership has to use these words at the last of the names. So, if the words LLP or LLP or any contraction or imitation is done, so for the last words, so unless duly incorporated, they would be punishable with the fine, and fine may vary from rupees 50,000 to rupees 5 lakh. That means it is compulsory to use these words. If any kind of contraction or imitation is being used, then in that case there would be a fine ranging from 50,000 to rupees 5 lakh. Next point is regarding the publication of name and limited liability. So every LLP shall ensure that its invoices, official correspondence and publication bear the name, address of the registered office and registration number. Registration number is being issued by the registrar on the incorporation of the LLP. So every kind of correspondence, every kind of publication, official publication or invoice of the LLP must include the name of the company, name of the LLP, the address of the registered office and the registration number of the LLP. So this was about chapter number 3, that is regarding the name and all that. Now we cover the chapter number 4, partners and their relations. So among this, the first one is eligibility to be partners. Who can be the partner of LLP? So any person who has subscribed their name to the incorporation document of LLP can be the partner of the LLP. So what would be the relationship of partners? It would be governed by the LLP agreement between the partners or between LLP and its partner. And in future, if any kind of change is there in the LLP agreement, so that must be conveyed to the registrar in the form which is desired by the act. And if there is such any subscribed fees, that fees must also be submitted. And this an agreement in writing made before the incorporation of LLP between the person may impose obligations on the LLP. So provided कि their name are rectified after the incorporation. Next is in case of absence of any agreement. So the mutual rights and duties shall be determined by the first schedule of the act. That means otherwise it is there when the LLP is being formed, the partners of LLP have an agreement, mutual agreement in which they decide the rights and duties of the partners. But in case of absence of that agreement, the provisions of first schedule of the act would be applicable. Next is cessation of partnership interest. A partner may cease to be a partner with an agreement with the other partners. How it is possible? By giving a notice, but that notice should not be given in less than 30 days to the other partners that I want to resign from the partnership of LLP. And a person shall cease to be a partner of a limited liability partnership on his death, on the dissolution of a limited liability partnership once the person is being declared as of unsound mind, or the person is being declared as insolvent, or declared as being or adjudicated as being insolvent. So in all these cases, a partner from the partnership firm can resign, can cease to be a partner of the LLP. But where the person has ceased to be a partner or partner of the LLP, so it is to be regarded as still being a partner of LLP, unless, means one person has ceased from the LLP, he has conveyed that or he don't want to be the partner of the LLP, but even then he is treated as if he is a partner, unless the person has given the notice to all the former partners that he has ceased to be a partner of LLP, or he has given the notice that the former partner has ceased to be a partner of LLP has been delivered to the registrar. Means one, the person has not delivered the notice. Second, he has this notice has not been conveyed to the registrar. That means a person can be seized or seized from LLP only by giving the notice to the existing members, to the former partners, and to the registrar as well. The cessation of partner from the LLP does not discharge the partner from any obligation to the LLP. So he would be liable for that. Where a partner of LLP ceases to be a partner, the former partner or a person entitled to his share in consequence of death or insolvency of the former partner shall be entitled to receive. Means, let's suppose one person, one partner of the LLP has got insolvent or is dead, and any other partner who is liable on behalf of that partner would be entitled to receive an amount equal to the capital contribution of the former partner. That means how much he has contributed in the LLP, that has the right to receive that, his right to share in the accumulated profits of the LLP. The LLP must have earned some profits, and that representative of the seized partner has the right to receive even the share in those accumulated profits. Next, a former partner or a person entitled to his share in consequence of the death or insolvency shall not have any right to interfere in the management of LLP. It is a very important point. Any person who has received the capital contribution of the former partner, or who has shared the accumulated profits of LLP, but that person would not have any right to interfere in the management of the LLP, because that person would not become the partner, or at the place of that he has certain rights which he can exercise, but he don't have a right to interfere in the management, in the operations of the LLP. Next point is regarding registration of changes in the partner. If there is any change in the partners, so every partner shall inform the LLP of any change in his name or address within a period of 15 days of such change. That means, let's suppose any partner has changes his official address, or has changed or has made some change into the name, or some designations. So in that cases, every partner has to inform the LLP within a limited period of 15 days of such change. And a limited liability partnership shall, where a person becomes or ceases to be a partner, should file a notice to the registrar within the 30 days of becoming or cessation of the partner. And if where there is any change in the name and address, so such change must be intimated even also within the 30 days of such change. So in short, if there is any change in the partner's name or address, so such partner should intimate all other partners, and this must also be intimated to the registrar within the 30 days of such change. A notice filed with the registrar under subsection with the notice regarding the change in the name, address, or or any change in the becoming or cessation of the partner. So such notice would be filed with the registrar with the requisite fees as is prescribed in the act, and it would be signed by the designated partner. At least one designated partner should sign it, and in case of incoming partner, a statement by such partner that he has consented to become a partner, and it must also be signed by that incoming partner is required, is must. Next, in case of default, LLP and every designated member will be punishable with the fine, and this fine would be at least rupees 2000, but it may be extended to rupees 25,000. So the default on in case of default, every designated member is liable for that. Next is any person who ceases to be a partner of LLP. He himself will file this to the registrar by the notice in the reasonable time, and reasonable if it has reasonable cause to believe that LLP may not file the notice. That means a partner who has ceased from the partnership has himself to file the notice with the registrar. So this was about the chapter number 4. Next is chapter number 5, extent and limitation of liability of limited liability partnership and partners. That means what would be the extent of the liability of LLP and its partners. So firstly, let's start with the partner as agent. Every partner of LLP is the agent of LLP, because every partner is working on the behalf of LLP. And agent, when the partners are the agents, LLP would be counted as the principal, but these partners cannot be charged as the agent of the other partners. Means all the partners are the agents of LLP, not among themselves. Next is extent of liability of LLP. A LLP is not bound by anything done by the partners in dealing with a person if otherwise, because the partners are the agent, the LLP would be liable, but LLP would not be bound if the partner has no authority to act like that and the person is doing a particular act which is not being authorized by LLP to that partner. In that case, LLP would not be responsible. The person believe him to be a partner of limited liability partnership. That means a person in actual is not a partner, but the other person other person thinks that a particular person is a partner of LLP. Means it is sort of a partner, is a partner in holding out, sort of that. So that means if any person believes him to be the partner by his act, and the limited liability partnership is liable if for a wrongful act or omission on his part in the course of the business of the LLP. Means LLP not liable if any act is done which is not in the authority of the partner, but LLP is liable for any wrongful act or the omission which is done in the normal course of the business of the LLP and is done by the partner within his authority. Next is an obligation of the LLP, whether arising in contract or otherwise, shall be solely the responsibility of LLP. The liabilities of LLP shall be met out of the property of LLP. That means if any kind of responsibility, any kind of liability has arisen due to the conduct of the partners, whether wrongful or whether rightful, during which were done under the normal course of the business, so such kind of liabilities are to be borne by the LLP, and that would be borne out of the property of the limited liability partnership. Now, the extent of liability of partners, as every partner of the limited liability partnership has a limited liability. So, a partner is not personally liable for any obligation solely by reason of becoming a partner of the LLP. Means where any act is done at the name of the LLP would be liable, not the partners. It should not affect the personal liability of the partner for his wrongful act or omission. And but a partner shall not be personally liable for the wrongful act or omission of other partner of the LLP. So this is the beneficial point, the basic feature of the limited liability partnership, that for any wrongful act or omission of the other partner, the other partners would not be personally liable. Then let's read the concept of holding out. Holding out is liable to any person who has, on the faith of any such representation, given credit to the LLP. Whether the holding out partner does or does not know that such representation has been reached to the person so giving credit, or the person is behaving on the or on treating him the holding out partner, this may or may not be in the knowledge of the holding out partner. But when such credit is received, the limited liability partnership firm shall be liable to the extent of credit received. So the treatment, the on behalf of the holding out partner, if any benefit is being sought, if any type of act is being committed, so in that case LLP would be liable to the extent of credit received. Where after a partner's death the business is continued in the same LLP name, it shall not itself make his legal representative or his estate liable for any act of LLP done after his death. Means if any partner of the LLP is dead, so if the existing members or LLPs working on his name, so the person's name, so the dead partner's estate would not be liable of any kind of act done by the LLP. Unlimited liability in case of fraud. In the event of an act carried out by the LLP with intention to defraud the creditors, the liability of LLP and partners shall be unlimited for all or any of the debts or other liabilities of the LLP. Means the main point is that the intention should be to defraud the creditors. But where any business is carried on in such intention, every person who was knowingly a party would be punishable with imprisonment extendable to 2 years. And with this imprisonment, there would be a fine which should be minimum 50,000 and which may be extended to rupees 5 lakh. That means in case of any kind of intention of defraud to the creditors, the liability of LLP and partners would be unlimited. And with this liability, they would be punishable with imprisonment and fine both. So partners or designated partner or employee shall be liable to pay compensation to all those persons who have suffered any kind of loss or who have suffered any kind of damage by the reason of such conduct. Next is whistleblowing. The court or tribunal may reduce or waive any kind of penalty leviable against any partner. But the court should feel that such partner has provided useful information during the investigation, such partner has favorably supported the case, or with the information of that partner or employee, any other partner has been convicted or any other benefit is being sought. So if the court or tribunal thinks that this is the any kind of waiver in the penalty can be provided, so it is totally dependent upon the decision of the court or the tribunal. No partner or employee of any LLP may be discharged, demoted, suspended, threatened, harassed merely because of he has provided the information to the court or to the tribunal, because this is the responsibility of a civilian to provide any kind of information which may helpful to the court, and on that basis he cannot be demoted, suspended, threatened or harassed. Next we come to the last chapter of this lecture, that is the contributions. So the form of contribution, a contribution of the partner may consist of tangible, movable or immovable or intangible property, including money, promissory note, cash or property, and contracts for services performed or to be performed. That means a partner may contribute in the limited liability partnership in any form. So that form may be the tangible, that form may be intangible, that form may be movable or immovable property. It may also include money, promissory note ho, it may be cash, it may be any property, or it may be any contract for services to be performed in future. But the monetary value of contribution of partner shall be accounted for and disclosed in the accounts of the LLP. Let's suppose one partner has given the certain property to the LLP. So if certain property is being given to the LLP, so then in that case the monetary value of that property would be counted for, and that monetary value would be accounted in the books. If it is being given in the case of in the form of money, it's very clear case that this much contribution is being made by the partner. But if it is being given like suppose the partner has contracted for service to be performed, then in that case the actual value in the monetary form would be calculated for such service, and that value would be shown in the books. So that means a partner who is going to be a partner in the limited liability partnership may contribute in any form, that may be tangible or intangible, movable or immovable, cash or non-cash, or even the contract for services to be performed in the future. So next is obligation to contribute. So obligation of partners shall be as per the LLP agreement. There is no compulsion on any partner to contribute a certain sum of money. So that contribution which one partner is to give can be decided in the LLP agreement, and as we have already read, every partner would be liable only for such decided contribution which was decided in the LLP agreement. A creditor of the LLP may enforce the original obligation against such partner. So this section, this chapter talks about the contribution, which is a compulsory feature of any type of firm, any type of partnership to be a partner of LLP. So in this lecture we have read about the first 6 chapters of the Limited Liability Partnership Act. So in summary, let's see what we have studied here. One is the introduction to limited liability partnership. So it is in which we have read that it is a hybrid form of Partnership Act 1932 and Companies Act 1956 or 2013. It has certain feature, means it has the perpetual succession. It is apart from it has separate legal entity. It is separate from its members. It can have the separate seal, etc. And among the chapters, we have first read about the preliminary topic. Then the chapter number 2 deals with the nature of the limited liability partnership. Chapter number 3 regarding the incorporation of LLP, that means how it is being incorporated. Incorporation document is being submitted to the registrar in which the names of the partners, designated partners must be submitted, and there is a condition that every LLP should have 2 designated individual partners, not the incorporates, and if there are at least one of the 2 designated partners must be the Indian. And under the chapter number 4 we have studied about the partners and their relations. Chapter number 5 deals with the limitation of liability, that in what cases they have unlimited liability, in what cases LLP is liable for the acts of the partners or not. And last, in chapter number 6 we have studied about the contributions of the partners while joining the LLP, that may be in the form of money, in form of movable, immovable, tangible, not or intangible property, and even the service contracts. So this is all about this topic, and this is the end of lecture. Thank you so much.